Hi everyone, good evening. Welcome to our discussion on the sedition law in India. My name is Mohsin Bhat. I teach at Jindal Global Law School. I also happen to be one of the editors at Article 14. And our event here today is basically to discuss the latest work by Article 14's team in order to collect all the sedition cases over the last 10 years. This is quite an unprecedented database that Article 14 has collected, because until now, many of us were relying on anecdotal evidence. Of course, those who study law were aware of the corpus of the Indian Supreme Court and the High Court. The practicing lawyers were aware of how the lower courts and the high courts, or sometimes the Supreme Court, deals with different aspects of sedition prosecution, bail, how FIRs are filed. But a large part of it was either anecdotal, or a large part of it was just based on our own experiences with the legal system. But the Article 14 database, the Decade of Darkness, and hopefully by the end of today's session, we'll have a better sense of why Article 14 called it the Decade of Darkness. Because of the database, we now have a much better sense of how the Indian criminal justice system interprets, applies, uses, misuses, abuses the sedition provision. Many of the things I'm sort of saying in the beginning is hopefully something we'll explore through the course of the panel. With me are two colleagues, Lubhyathi and Kunal. I hope that both of you are, as in the audience knows, both of you quite well. Lubhyathi is my colleague at Article 14. She's the head of our database section. She led the sedition database for many months. We saw her working really, really hard at bringing together quantitative and qualitative analysis in order to create this database. And just know that my colleagues would have put up the links to the database and some of the key stories on the chat box. So please do explore that while we are discussing these things. And then the second guest is Kunal. He is a courageous, seasoned reporter journalist. He has written for Article 14 a number of really important stories, my own favorite being the ones on hate crime very recently, and of course on sedition as well. So what I will do is, before proceeding to ask a series of questions in the spirit of conversation, and that's how we'll structure today's panel, and go to Lubhyathi and Kunal, just to give our audience some sort of a broad sort of introduction to what this sedition provision is really about. How much do we know? And hopefully get a chance to dig really deep into some of the key problems or issues and questions that the sedition database illuminates. As many of you may know, the sedition provision is Section 124A of the Indian Penal Code. This is a colonial provision, and some of great anti-colonial leaders of this country have been prosecuted by the British Empire under this provision. And the text of Section 124A says that whoever brings in hatred or contempt or excites disaffection towards the Indian government is punishable under this provision. Now, any careful listener would know that this provision is full of words and phrases that are really open, really susceptible to multiple interpretations. So whether it's hatred, affection. And of course, anybody who is a keen observer or student of the Indian Constitution would also immediately know that this provision seems to run, or appears on the first reading, to the very least, run counter to our free speech right under the Constitution. Article 19 of our Constitution guarantees freedom of speech, and there are very few grounds on which this freedom can be limited. So for instance, under public order, public morality, and public health. But the sedition provision, Section 124A, makes no reference to public order. Even on the face of it, a bare reading would suggest that it seems to contradict with the Constitution of speech. So then the question is, how come this colonial provision, after so many years of Indian independence and the Indian Constitution, continues to be implemented by the Indian state? And part of the reason for that is that the Indian Supreme Court has not, arguably, taken a strict view of the constitutionality of Section 124A. In 1962, the Indian Supreme Court, in a seminal judgment called Kedarnath, ruled that the sedition provision was constitutional. And it's not that the Supreme Court was unaware of the problems with the language of the sedition provision. The language was, as I said, open to multiple interpretations. It could very clearly be, could also be used against people who may not even be disrupting public order, right? But what the Supreme Court said was that, of course, we are aware of these possibilities, but we will narrowly interpret the law, even going against what the language of Section 124A suggests. And I believe, even at the danger of credulity, it tried to narrow down the language of 124A, the interpretation of 124A, to say that, well, only those kind of speeches or those kind of representations that may lead to violence may lead to public disorder can be prosecuted under 124A. So disaffection against the government is not any kind of disaffection, but there has to be some connection with violence. But in my own view, what made Kedarnath a particularly dissatisfactory judgment was that even the judgment itself was open to multiple interpretations. So for instance, in one place, the court says that the speech should use, the speech should either use actual violence or there should be incitement to violence, which is one way of interpreting the sedition clause. But then in other parts of the judgment, the Supreme Court says that it would be enough if the speech incited violence or had, to quote unquote, the tendency to create public disorder. Again, the phrase tendency to create is again subject to multiple interpretations. And as we see, even though the Supreme Court upheld the sedition, even though it tried to narrow it down, both the language of the Supreme Court sort of did not really clarify the matter, but fundamentally it seems that Kedarnath in 1962 was a bit too optimistic about how the Indian criminal justice system tends to implement the law. It just assumed that the police and the other actors in our legal system would follow the court's narrow interpretation rather than what the law appears to lay down textually in the law books. So hopefully, with these sort of larger questions in mind, we can now go to both Lubhyathi and Kunal and explore some of them, because the database gives us a great opportunity to both look at some of these legal questions, which I hope we keep in the background in the conversation, and also the systemic questions about how the different limbs of the legal system are addressing or are using the sedition provision, how are they understanding it, and how are they implementing it. So there are specifically 5 themes that I wanted to bring up in the course of the next little less than an hour. The first is democracy. After all, free speech is central to democracy, and in a democratic system, there's barely any other right which is more important than free speech. So what is the impact of the sedition provision in terms of its implementation on India's democracy? The second is, what is the arbitrary nature of the provision? What does this database tell us about how the legal system is implementing it? Is it arbitrary? Is it not? The third is, what are the legal process violations of the legal system? What are the courts doing? What is the police doing? And the fourth is, we often hear about the sedition provision and many other provisions that the process itself is a punishment. How does the process of being subjected to the sedition database really look like? And finally, hopefully we'll also get to talk about how did the team at Article 14 build this database, because as you may have noticed if you've seen the database, it has a remarkable quantitative breadth, but it also has really wonderful qualitative journalistic stories. It's based on a collaboration among different kinds of people from different disciplinary fields. So hopefully we'll also be able to discuss a bit about the methodology. And before I come to our guests, a small sort of point for the audience members: feel free to type out your questions in the Q&A box. I'll be happy to integrate them in my conversation. And I'll make sure, obviously subject only to limitations of time, to take all your questions to our guests. All right, so with that, I'll start this conversation. Thank you, Lubhyathi and Kunal, for joining us. The question, as I said, which I wanted to start off with, was the question of democracy. Right? We are concerned about what the impact of this provision has been on the health of India's democracy. And one particular point of data that struck me from the database is that last decade, the sedition cases have been filed against 405 Indians nationwide for criticizing politicians and governments. And 96% of these registered cases have been registered after 2014. And another fascinating data point is that 149 of these have been accused in 18 sedition cases for making critical or derogatory remarks against Prime Minister Modi, 44 against Yogi Adityanath, Chief Minister of Uttar Pradesh. So clearly there's a political story here. And what I'm sure we would be curious about in the audience as well is what is the impact on criticism and on protest? So maybe Lubhyathi, you would want to start off with that first.
Yeah, thanks, Mohsin, for that wonderful structured introduction to our conversation, and for the Center for Public Interest Law for having me here. The short answer is yes. Sedition has the fear of a case being filed against you for criticism and protest is sort of rampant in the country right now. And I'll give you another, you pointed out all of our empirical data, but I'll give you a couple of examples of anecdotal data that we picked up. For instance, in COVID, we had cases of sedition being filed against an MLA in Assam for holding a press conference to talk about, what are the quarantine measures in place. Now, again, to go back to your interpretation of Kedarnath Singh, we can bring the audience back to your summary of Kedarnath Singh and whether that fulfilled those conditions, but we can get into that later as well. Another instance was of someone in Ludhiana asking for ventilators on Facebook during COVID times. And this was incidentally a BJP party worker, according to the news story. In Manipur, there was a person who posted on Facebook, again, asking about the name of their local MLA for food distribution. That was the nature of the post. Now, in none of these cases, some of them may not even be criticism. Again, something that Section 124A very clearly lays out, that criticism of the government is not sedition. Lawful criticism of the government in peaceful ways is not sedition. But again, our empirical and anecdotal evidence, as Mohsin pointed out, suggests that after 2014, certainly this kind of need to just file FIRs against people, not even for criticism, even for a comment, like asking the name of your MLA, is also deemed seditious. So another example, of course, in UP is around the Hathras cases. Now, there, what the government did was to file at least 19 FIRs across multiple districts in UP, blanket FIRs, not naming anyone in the FIRs, for creating a conspiracy to defame the government. Those are the facts of the FIR in the Hathras case. So this is anticipating trouble, anticipating criticism, and anticipating protest. So it is not even now the actual fact of the protest happening. You have cases being filed or FIRs being filed against unknown persons. Again, another sort of method that the police is now using, before the actual criticism, before an actual protest. So this kind of anticipation of a protest is also part of the playbook now of the criminal justice of the police to file the case. The other thing, of course, is as lawyers, what we need to be aware of is certainly the politics of of sedition, the politics of who decides to file the FIR against whom. So this is not simply, of course, a legal question of the facts of that particular case and whether there was incitement to violence and whether it upheld a certain standard. Yes, that is a separate question. But what we discovered in our data, and this is again borne out through our data on complainants, again, something that's a very unique feature here. And there's a reason we included it, because even in cases of criticism and protest, even where people make comments, you on social media especially, you can have somebody take a screenshot of that comment or that criticism, share it with the police, and the police then takes it up and files an FIR against you. So this kind of, private, so-called private complainants also keeping an eye out for who is critical of the government is another facet to sedition that we need to be aware of, that it is no longer just investigating agencies that are keeping an eye out for this, but you also have private, quote unquote, private parties or private individuals who are doing this. So all of this, yes, put together, this kind of, cocktail of social, political factors, private citizens being co-opted into this, sort of surveillance, is part of why we are seeing this declining health of our democracy, because it is, it's no longer, we're no longer also in the realm of the law. We're very much in the realm of, politics, and which party being in power having an impact on the kinds of sedition cases that are also being filed against those who are critical. So again, Chief Minister Yogi Adityanath is, he has been quite harsh on critics of his government and of himself. So for example, anybody posting on social media, joking about him or a meme about him is also now facing sedition charges. And we have cases in UP of people like that. Again, now is this criticism, is this legitimate criticism, is certainly a question to be decided. But the fact is that there are certain parties, and this government in particular, and also at the state level where they are in power, that you're seeing a rising number of sedition cases being filed. And that's why you see that happen more after 2014.
Thanks, Lubhyathi. Before coming to Kunal, just wanted you to elaborate just for a few moments. There's a really important point about the nature of surveillance that provisions like sedition create. And the important thing you said was it's not just the investigating agencies, but a large number of quote unquote private entities, persons, organizations that are doing it. And the reason I want you to elaborate on this is because that was my next question to Kunal. You have interesting data on it, right? So what does Article 14 tell us about the breakup of the complainants, particularly when it comes to these kind of organizations? And if you need time to pull up that data, I can go to Kunal first, and then I can come to you.
No, actually, I have pulled it up. So what we've done, what we found, is that, so apart from investigating agencies who are, of course, the police, central investigating agencies, who are meant to file the FIR, what you now have are a whole range of people. And here we have data on, for example, even academics and students, activists and groups, employees and businesses, that is people who are just private, business owners, government employees, Hindu extremist groups, political party affiliates. So that is, a party in power or a party worker in power might file a sedition case against somebody in the opposition. You also have university administration complaining, as we've seen in certainly in JNU, when there were protests happening there. So, what we are also, I think part of that, the reason for categorizing all of these groups is also not just to put them in one block as private parties, but to show you the range of occupations they are also from. Because again, not everybody is affiliated to a political party. Not everyone may even be affiliated to a group. You could be just, a private citizen and just feel offended that somebody has posted something about Yogi Adityanath. For instance, actually, in Karnataka, we had a case where, a group of people in different districts sort of liked a Facebook post. This was in the aftermath of the Pulwama attacks in 2019. And, somebody on their friend list, certainly in one case, somebody on their friend list on Facebook took the screenshot of that particular post and shared it on, shared it with the police. So this sort of thing, again, on common WhatsApp groups, we have noticed this happening. And again, from our investigative work in Karnataka, we found this, where in one case, a shop owner just sort of, shared a video that he thought was a nice video. And somebody else on the WhatsApp group took that up with the police. So there are screenshots being shared on WhatsApp, and these WhatsApp groups again are created, and in this particular case happen to have a lot of the local villagers, local MLAs and MPs, and sort of, so a lot of content being shared on these groups. We also have WhatsApp admins who are being, have cases filed against them by other members on that group, who may then take a screenshot, share it with the local police, who are also now on WhatsApp and are quite active. So again, the police also has their own cybercrime units where they are keeping a tab on what people are doing on WhatsApp. And these local groups, as we have found in some of our cases in Karnataka, are actually where we see this play out in practice. How does this content travel from that phone into the phone of a police officer and finally into the FIR, which then gets that person arrested, as we found, in about 30 minutes from the time they posted. So it is also the speed of that happening that should concern us.
Thanks, Lubhyathi. Kunal and Lubhyathi really put out for us a potentially very scary picture, right? So we have a provision that is really amenable to multiple interpretations. We are in a legal system that is really open to potential misuse. In addition to that, we now, as Lubhyathi said, have a way in which it's evident that there is a political character to what is going on, the kind of complainants. And it seems that in a very vulgar sort of way, the sedition provision has allowed some democratization of prosecution. And anybody can raise these questions anywhere, in any form, against anybody saying anything. In your experience, what is going on? What is the evolving political character of the sedition provision? And what are you, after all these stories on the ground, worried about the most? You'll have to unmute yourself.
Thank you for the question, Mohsin, and just a big thank you to the organizers as well as everyone who's present in this room. It's a very pertinent question, especially in the backdrop of what you and Lubhyathi have so elaborately laid out. One of the things about sedition that we've sort of not really paid attention to in the past few years has been that critical lens that sedition really, not just now, but even in colonial times, in fact, has always been some sort of an agent of validation, for the political regime in power. So it becomes a tool which the regime can then use to validate its political priorities at that point. So for colonial India, it used to be the prosecution of Indian nationalists. For UPA too, after Prime Minister Manmohan Singh says that the biggest internal security threat that India faces is from left-wing extremists, it becomes a tool which can then be employed against that group. So it was always supposed to be some sort of an agent of validation for whatever the state's priorities were in that particular time. And that's exactly what we're seeing here as well. What is now dangerously happening, and one of the reasons why, and I think Lubhyathi might be able to elaborate on this better, one of the reasons why we're also calling it a decade of darkness, especially the last 7 odd years, is that we've seen a tremendous rise, a tremendous sort of weaponization of that existing political tool of sedition. It was always about imposing the state's brute power on anyone you thought was harmful, anyone whose political ideas didn't match yours. But now, unfortunately, what is seeming to happen over and over again is that sedition is now also being used as a tool to other, anyone else who you want to. It could be a group of people from a different religion. It could be a group of critics in a particular matter, but it's about othering those people and using sedition to employ that effectively and to ensure that it happens in a way that the impact remains in society. And allow me to give you, a few examples of what we found. We found, how almost at every point in time in the last 7 years, especially, whenever there has been a conspiracy, by the government says that there is a conspiracy against it, or whenever there have been mass protests, whenever there has been some sort of a political conflict, not necessarily a violent one, but a political conflict that the state faces, it has used sedition against it, in a way to try and crush those dissenting voices and to impose its writ on people. So we saw that, even after the CA and RC protests, the favored choice for state governments across the country, but especially in UP, was sedition. It would impose Section 124A on protesters who were protesting for very fundamental rights of citizenship. We also saw it after Hathras, as Lubhyathi has pointed out. I remember also seeing it during Pulwama, and this is why I say the othering of it, and sedition being a very convenient tool to other people without the state really having to do anything more than that. I remember after the Pulwama terror attack, I was, as a part of my work as a journalist, I was tracking a lot of, frequently sort of active networks of disinformation. WhatsApp groups, Facebook groups, the regular kinds, where disinformation would really flourish. And what I saw at that point was that after the Pulwama attack, there was a very concerted attempt to, pin the blame onto Kashmiris and Kashmiri Muslims for letting the terror attack happen. Now, it's interesting because at that point, questions should have been raised of the state government, of the state authorities, of the national authorities. And whether this was an intelligence failure, whether the authorities failed to act in time to prevent the Pulwama terror attack. But instead, I saw that there were very, very concrete attempts being made to spread disinformation about how local Kashmiris were possibly involved in it and possibly had a role to play in letting the terror attack happen. What we did see from there on, and I reported about this back in the day for First Post, what we did see from there on is a spate of sedition cases being filed against Kashmiris across the country. From something as simple as them putting up a post which apparently congratulates the Pakistani army, to them celebrating the attack, and as some of the wonderful stories that Article 14 is then carried, by one of my colleagues, Mohit Rao. The stories point how so many of these people who were then arrested for putting up these statuses or putting up, posts, were people who were either semi-literate or possibly, had no knowledge of the language at all. So they were sharing posts which they thought were congratulating the Indian army, but somewhere in the bottom was an English inscription saying, whatever, I support the Pakistan army. Now, so you understand how the state sets its political priorities. And in this case, the political priorities were very clear through the disinformation networks I was tracking. Many of these networks were run by people who were close to the BJP or were, an extension of the BJP. And then the state going ahead and imposing, the sedition clause on all of these people. So what does happen is the state's agenda, state's priorities at that point, which is to pin the blame on a group, is validated by the fact that now there are legal cases which are also saying the same thing that the state was saying informally. And I think this is the othering is what has been so dangerous about this political regime. And the fact about the othering is that it doesn't stop at anyone. It didn't stop at the Kashmiri Muslims. It didn't stop at the CA and RC protesters. It's now spread to people who are dissenting in all forms. As Lubhyathi has just told you, and as you've discussed this yourself, Mohsin, critics, dissenters, people who've criticized, people who asked really for very fundamental things, like oxygen supplies or better COVID testing in Karnataka, for instance, have now been slapped with sedition. So when you look at it, it's really an agent of validation which has now been taken to the very extreme, which is that it's now also being used to actively other people, whose political stances might be different, people who the current regime finds to be critics, people who the current regime finds to be threats. And that is so dangerous. That is what is so dangerous about the current use of sedition in the last few years, especially.
Thanks, Kunal. Lubhyathi, carrying that forward and perhaps digging a bit deeper and perhaps adding another layer, let me just sort of say that, is beyond, in addition to the question of democracy, is also a question of arbitrariness, irrespective of which government it has been. After all, this provision has been much older than 2014, and as the database shows, from 2010 to 2014, it had been used by a number of state governments that are not necessarily ruled by only the same political party. And I'm sure even in those cases, the problem of arbitrariness arises. Of course, there may be a question of political risk and risk to democracy, etc. But what is the story of arbitrariness in addition to the political story? How is the provision being implemented in different states across party lines? What was happening before 2014? And what would strike you as examples of arbitrariness of the law, or non-arbitrariness, whatever your assessment is?
That's quite a quite a broad question, Mohsin, and yes, it certainly gives us something to think about. Now, I think to first, I'm glad Kunal mentioned the sort of trajectory that sedition took, at least in our data across 10 years. So, that I would say the first example of arbitrariness is simply that under this particular regime, the UPA2, you saw a certain kind of political priorities playing out, which then led to sedition cases. And under this, the last 6 years, you saw another kind of, a set of other kinds of cases being filed. Now, this might be, one kind of arbitrariness around sedition, simply because the provision is so broadly worded. It is impossible to not have it be arbitrary in terms of the kinds of cases you file, depending on who is in power. To the sort of other question, again, I will try and frame this in terms of arbitrariness, but what I will also point out in our database is we have a category called the everyday. Now, this is a category that we, internally discussed. We discovered, let me put it that way, we discovered this category in the course of our research. The everyday is a set of cases where there is no active element of protest or criticism. It is, in fact, these are cases where people just did seemingly very innocent things, like, for example, wearing a t-shirt. Now, the t-shirt, of course, had the words Pakistan Cricket Board inscribed on it. But no matter, the fact is that they were wearing a t-shirt. The second was dancing to a song. This was in Bihar. Now, in this case, there were at least about 7 people, some of whom were juveniles. Even the DJ playing the song was arrested of sedition charges. The lyrics of the song were seemingly offensive, and therefore they were arrested under sedition. But the point is, it was a song that 7 people were dancing to. There's also a third kind of very interesting case that we found from our fieldwork around victory processions by opposition candidates. This is in UP, and this is Zilla Panchayat elections. Now, what happened in these cases was that you had a group of people who, of course, won, who are not the BJP, and cases were filed against them after their victory procession by, seemingly BJP workers for shouting the phrase, Pakistan Zindabad in the victory procession. And this is something they would record on their phone and they would send it to the police. So the reason I bring up this category of everyday, again, this is let's bear in mind that this is a victory procession. It's not a protest, it's not a criticism, it's nothing. It's just people celebrating the victory of their electoral candidate. Now, these kinds of cases also beg the question about how the law is being used, because if you do look at the provision, sedition is only meant to be used against people who incite disaffection, and not even against those who criticize lawfully. So how does wearing a t-shirt or dancing to a song or taking out a victory procession, or in one case, where a sedition case was filed in the aftermath of a marital dispute between 2 families, between the husband and wife. Again, the FIR, and we have a copy of that FIR, this was in Karnataka. The FIR makes no mention of why sedition was put in. Seemingly now, and what we have seen from all of our evidence, empirical and qualitative, you could just be accused of having shouted anti-national slogans, even in a private dispute, a marital dispute, and you can still have sedition filed against you. So this is the kind of everydayness also of sedition that we're seeing, which then contributes to the idea of arbitrariness. And this is at the FIR level. So these are not even cases that have been adjudicated to the point where we have a court judgment telling us, yes, this was arbitrary, this was unreasonable, this was not a case in which sedition should have been filed. So, when we talk of the question of arbitrariness in sedition, how the law is being used, and again here, I what we also see a lot in public discourse is the idea of misusing sedition. And I sort of have a quarrel with that word misuse of sedition, because I do believe that the way the provision is worded, one, and two, the fact that the law and Kedarnath Singh, which upheld sedition, are silent on who does the interpretation of this law, which sort of organ of the government is meant to interpret the law, at what point, is also what then leads to the arbitrariness. So in a case of a victory procession, a sedition case being filed in a victory procession, who decides? So clearly the police are saying, we are just going to file the case. We will file the case and say, yes, allegedly there was a slogan shouted. Now, again, even a slogan shouting is not per se seditious. We have another judgment of the court, Balwant Singh, to tell us that, of the Supreme Court, where just merely shouting, two people shouting slogans is not seditious. But what's also contributing to the arbitrariness is the fact that Kedarnath Singh is, and to add to what Mohsin was saying in his introduction, Kedarnath Singh is very unclear on who makes this interpretation of incitement to violence, of tendency to violence. Is it the police doing it at the FIR stage? Should they be doing it? Or is it the court at a remand or a bail hearing who should be deciding, do we need to take this case forward? Is it the court then at the stage of, say, sanction, when before the government or after the government gives sanction at the time of framing of charges, that they decide, okay, no, it is arbitrary, this case should not go forward? So, at what point does the police or the court decide that this provision is meant to be used? So there's a lot of sort of distance between, I would say, even the law, the interpretation of the law, the implementation of the law, and the local police thana, which adds to this absolute kind of, I would say, chaotic interpretation of sedition across political parties, across even legalese. That is, it sort of defies legal logic. There is really no other way to say it, because how does a T-shirt incite disaffection against the government? I mean, how do you, which sort of judiciary is going to go ahead, invest public money to prosecute all of these cases? Because we haven't even spoken of prosecutions yet. So, which is something else that our data points out. And, again, to add to this question of arbitrariness, so our data also tells us that we only have 0.1 conviction rates at the end of 10 years of data. So that is telling you that while there's a funneling of sedition, while you have a huge net being cast in terms of all kinds of cases, all define, and we have categorized all of these cases, through criticism and protest and the everyday and counterfeit, financial fraud. So the net is being cast very wide by the executive, and it sort of slowly then funnels down into the legal system. And at the end of 10 years, we only have 10 convictions. And in these, 126 acquittals. And in the acquittal judgment, the court will say sedition should not have been applied. So why does it take you that long to say that? Should you not say that at the FIR stage? Should it not be decided then, the question of arbitrariness? So I think, again, this is a sort of very broad answer with multiple sort of facets to it, to answer this question of arbitrariness in sedition, the use of it, or the quote unquote misuse of it. Because from our data, what we have seen is, because of the way the provision is worded, because of the way it's being used, it appears that there is no misuse. It is being used exactly the way it was intended, and exactly the way the legislature intended it, because anything could be disaffection. And even if it is criticism, who decides it is criticism at what point? So even if the court decides it's criticism, if they decide that after 10 years, or that it is not criticism, I mean, it is not a seditious case, after 10 years of the FIR being filed, what difference does it really make?
Right. Kunal, I just wanted to ask you, because one interesting thing which Lubhyathi pointed out was that, there is a fair bit of politics here, but there's also what I think Lubhyathi called chaotic way in which the law is being interpreted, as if there's no interpretation. There's no logic to the interpretation. That's what she said. So let me sort of make your life slightly harder and say, what is the logic? After you've been in the field and you've seen how the legal system is responding and the police are responding, is there any logic to how this provision is being interpreted? Is it different from other provisions? Because another striking thing about the database is that not only does it tell us that forgery and counterfeit currency cases involve, the sedition provision is thrown into the mix, but also this provision is used consistently in, say, for example, UAPA cases, which we have not studied specifically. So there are multiple provisions being used together. And then also colloquially, I imagine from your stories, that the word sedition is interpreted as deshdroh, which also doesn't help in any sort of clear interpretation of what the provision should be. So in your experience, what is going on in the way the police and the prosecution interpret this? And is there any logic to it, or is there none? And that's precisely what the problem is.
I think to understand that, Mohsin, one also has to then look at the larger political climate that we're living in. Where nationalism is sort of the top billed currency in some ways, right? So for everything, for instance, as you said, deshdroh is really, as high as it gets in terms of trying to label someone as that. Which is why on the ground, when I go and meet people, when I meet police officers, when I meet victims, when I meet the accused, one thing that I realize is that the police officials on the ground, when they're applying these charges, are taking their cues from this political climate that we're in. So for instance, a police, and this is again anecdotally, but if I go to the ground in Maharashtra right now, I can say with some sort of certainty that the police officer will not be very happy, sort of applying the sedition charge on a very similar offense that happens here. But if you go to a different state ruled by a different party under a different political climate, I imagine that the police officer will want to do that, because again, he's taking cues from the regime that's in power locally as well. So that's one aspect. And just to give you an example of what I found on the ground, in fact, just a couple of months ago, I was in Kasganj, where there was a deadly communal riot that had happened in 2018. One ABVP activist was dead by the end of it. Lots of people on both sides, were injured. Now, what I found interesting was that there were multiple FIRs filed. One was for the death of the ABVP activist, another one was for other things. There was violence. But the interesting part that I found was that there was one FIR which specifically, had the sedition clause. So it had 124A, but that was only imposed on 29 people from the Muslim community. So now imagine this is a communal riot. Both sides, and there is clear evidence to show that both sides have been affected. You have Muslim shops and Hindu shops both being burnt. You have vehicles from, belonging to people from both communities, which were again charred to dust. And yet the sedition clause is only applied to members of this one certain community. And I think that tells you so much about the arbitrariness of things. And which is why I say that I think to understand sedition and the use of sedition in today's India, you also have to look at the political economy of sedition, right? So you have to go to the ground and you have to understand, as Lubhyathi pointed out earlier, you have to understand who are the actors who are pushing for these charges to be imposed. Often I find on the ground that as soon as something like this happens, the Hindu right-wing groups in that locality get activated. They rush to the police. They often sit outside the police station, refuse to leave till an FIR of their liking has been registered. There's often violence that happens on the ground. For instance, in some of the cases in Karnataka, we've seen how when one of these sedition FIRs was registered against some Muslims, the mosque in which they used to pray had then been ransacked by a Hindu mob. So you often see that the political economy of sedition in all of these places is active on very different levels. So one is the Hindu right-wing groups activated. The other is a group of lawyers as well. So the local bar association, lawyers affiliated to the BJP or to any of its other groups which are ideologically similar. All of these get activated. And as a result of which you finally see that the sedition charge is then imposed on certain people, but not on others. So I feel like the arbitrariness comes from some of these elements as well.
Thanks, Kunal. Before coming to Lubhyathi specifically to elaborate on how the courts are dealing with this in slightly greater detail, I wanted to ask you something, Kunal. Now, one thing which Lubhyathi mentioned in her previous response was the low degree of conviction rates, quite dismal. And Lubhyathi's response also was that a major reason for that is that most of these cases, forget about being misinterpretation of the law or arbitrary use of the law, they are absurd of the law. Many of these cases do not even involve saying anything, which is what often the understanding of sedition is. Forget about whether it causes or may cause violence or not. So my question to you would be, what is the impact of this process on the people? Let me just call them the victims of the law. And what kind of pressures do they have to live under? And what kind of losses do they have to suffer only in order to deal with the sedition proceedings? And once you have a better sense of that, over to you, Lubhyathi, if you could also then tell us, then the bail proceedings become important, then what the role of the court even before the merits becomes really important. And the sedition database really illuminates that. So maybe after Kunal tells us a bit about how this process itself appears to be a punishment, then Lubhyathi could tell us what the courts are doing in this mess.
Absolutely. I mean, one of the things that I often find is, and the database gives us enough evidence of that, is how common people who have nothing to do with politics, who are not inherently political actors, often are charged with sedition, and their life sort of takes a very different turn. There is a case that the database records of someone who had forwarded a bird rescue video. So the video was literally a bird being rescued by someone, and he forwarded that video to a few other people. And within minutes, he had the police at his doorstep, because at the end of the video, there is a voice in the background saying Pakistan Zindabad. And this person had not really reached the end of the video. He thought it's a bird rescue video, and it will be a good thing to share. Now, someone like that, for instance, when you again in this political climate, and I keep emphasizing this political climate because it's so essential to understand that the use of sedition right now is a product of this political climate, where nationalism is constantly on the political radar, especially of the ruling regime. So in such a climate, when you have the tag of a deshdroh or for deshdrohi in a local context, their life often gets very, very difficult. Right from societal censure to some sort of ostracization. Often in these cases, we're also seeing communal violence that happens after the incident has happened. So in many ways, these people suffer different consequences. And for instance, I had interviewed last year Asim Trivedi, who's possibly one of the most well-known cases of someone being charged with sedition. The cartoonist, and he was charged by the UPA too. Now, he told me, despite all of the support that he got, which is a lot in comparison to what victims today get, or people who are accused of sedition today get, despite all of that, he said, he did not get as many economic opportunities as he would have liked to set his life back on track. So he was lucky that he got a lawyer who agreed to not charge him fees. He was lucky that he got the media rallying behind him. The sedition cases, the sedition charge was dropped a few years later, but he's still not able to get his life back on track for the, in the economic sense, because he still feels that people often hesitate to work with him or hesitate to be seen with him on the same stage. Now, if this is happening to someone who has been so extensively covered in the media, who has even been a part of the Big Boss reality show, you can imagine what could happen to someone who's in a rural district somewhere in Uttar Pradesh or Karnataka or somewhere else. So yes, I mean, the punishment is immense and in many different ways. There's also, and Lubhyathi will, I think, elaborate on the fact that these charges also come with multiple court visits, a lot of paperwork, the fact that they have to furnish bail bonds, the fact that this brings immense financial constraints on the families as well. Because what the database finds is often that these people were primary breadwinners for the family. And when the soul of the primary breadwinner goes inside prison for sedition, the family has to suffer cascading effects of the same. So I think Lubhyathi might want to sort of take ahead from here and talk more about how the process itself then becomes a punishment.
I'll illustrate that with just one very recent example. So after the T20 India-Pakistan match in one of the group rounds, Pakistan won the match. And again, in the aftermath of cricket, which is a category under everyday, so not criticism, not protest, just people going about their business and celebrating the match. There was a sedition case filed against 3 Kashmiri students in Agra, in UP, for allegedly celebrating Pakistan winning the cricket match. Article 14 actually has done a very extensive ground report on the legal process that the students went through and the impact of the case on their lives. But they have been granted bail by the High Court, but they are unable to pay bail bond and surety because their family is too poor to post that. But before that, they had spent 155 days in jail, at least 5 or 6 delayed bail hearings. The local bar association boycotted them and sort of ghirawed them on the court premises when they were being brought for the for their various hearings. The local bar also stopped anybody else from representing them. Of course, they finally did get representation, but from what we have found on the ground, from the interviews with their families, all families, I mean, of all 3 students unanimously have had to sell their land, other assets, jewelry, borrow money locally to just pay for legal fees, to be able to now pay for their bail bonds. The families are again sort of getting together and pay for that. They have not been able to visit their children in all of this time, in all of these 150 plus days. And in fact, this is also what our database tells us. In our category on courts, we have found that in a lot of cases, people spend at least up to 200 days in jail. And for cases such as this, for cases that we have so far been describing to you over and over again across criticism, everyday sort of categories, so people have spent at least up to 200 days in jail before the High Court grants bail. So trial courts are also more likely to reject your bail. But if you are, again, and coming back to that question of arbitrariness, who gets to even afford to go to the High Court is another question. Who can even afford a lawyer to appeal to the High Court is, again, depends on your financial and economic, social capital. Another example, and this is something else we've documented, is on the question of anticipatory bail. Again, we have data on the number of anticipatory bail applications. But again, anticipatory bail is before you are arrested. And so this is also a sort of privileged, legal remedy that you are able to afford a lawyer to post your bail before you are even arrested. So not everybody is able to even afford that. So, again, to the question of the process being the punishment sort of ties in very closely to the question of arbitrariness. As we see also, for instance, the kinds of people who may approach the Supreme Court for remedy is very different. You might have very senior journalists who recently, in a case after the Red Fort, farmers' protest, Shashi Tharoor and, a lot of Rajiv Sardesai and a lot of journalists had tweeted something, and they were sort of immediately able to approach the Supreme Court to prevent any action being taken against them. This is not a remedy available to a lot of people. So other than the fact that the process is the punishment right from the time that the FIR is filed against you, until the time you get bail, and we're not even going into the question of actual trial, which again takes several years. And as Kunal pointed out, and as we have also discovered from all of our reporters on the ground from UP, Karnataka, and Assam, it is unanimous that families are having to sell land, debt, take on debt, lose education, especially in cases where they're students, so they are not able to go to school anymore, not only because they cannot, may not be able to afford any fee, but also because they are traumatized, also because they may be bullied for this idea of being a deshtro, again, something Kunal alluded to earlier. So, these are all the factors that contribute to the process being a punishment, in addition to the fact that, yes, you have to travel multiple times to, another district because you may belong to a, smaller rural hamlet. And so you have to, and in one case in Karnataka, we interviewed a daily wage laborer who then said, I end up losing my daily wages just because I have to go to the court and report there, or go to the police station and report. So then I cannot work for that one day, and so I lose my 300 rupees for that one day, because the legal system has now kicked in and is forcing me to go and travel there and report for cases, again, that may go on for years and years before it is even concluded. So it's, this is a sort of, I would say, complexity of just one sedition case, as well as who can afford, simple questions like who can afford a lawyer, which lawyer is even able to represent you, because often locally these cases tend to not attract, somebody who's just willing to come forward and represent you, because they're all anti-national or all deshtro, and so nobody is willing to take on that sort of controversial case. And the question of local bar associations also boycotting that I referred to earlier. This happened again in Karnataka, again with 3 Kashmiri students in the aftermath of the 2017 Champions Trophy, where again India lost to Pakistan in a series match. And there too, the local bar association said nobody is going to represent them. But the High Court fortunately stepped in. The Chief Justice of Karnataka High Court, in a bail hearing many months later, also, came down on these bar associations that this is absolutely not, this is not acceptable and this is not ethical, and you cannot boycott anyone from representing them. But this is, of course, again, one sort of instance. We don't know if it happens otherwise. It certainly didn't happen in UP recently, in the aftermath of the T20 World Cup for the 3 students. So, this is sort of the way in which the process is punishing, both inside the legal system and outside of it.
Thank you so much, Lubhyathi and Kunal. We've almost run out of time. I had just one small question, but just wanted to sort of highlight what you've told us until now, which is how this provision is sort of interpreted in both in a highly political manner to target people. It's also quite chaotic, considering the number of absurd circumstances in which it is being used, which gives us a really complicated picture, both at the local level as well as the macro level of the nature of national and state level politics, and the nature of victimization of the people who this law tends to target, or the legal system tends to target at various levels, either in terms of othering, as Kunal said, by really sort of branding them as deshdrohis, or as the process itself and the kind of investment and the kind of money that the legal process itself requires is quite striking. I wanted to conclude quickly on a methodological question. I think our audience members, and I encourage them to look at the database, and you will see that it is quite a remarkable sort of coming together of legal and academic quantitative research using online tools, and also working with journalists on the ground in order to get some amazing stories. We've practically run out of time, so maybe it's not fair to ask you to give sort of an elaborate answer. But first, Kunal, if you're telling the audience members about your methodology, what would be a quick way of telling them and introducing them to it, in the hope that others also pick it up for other kinds of projects?
So just very briefly, I think this this whole project has been an excellent example of what both the media and the academic world right now needs, especially in conditions where we're constantly blaming the media, and we're believing that the media isn't really representing and reporting what is happening on the ground. So Lubhyathi will take you through the processes that she employed at her end in terms of data mining and sourcing. But all I want to tell everyone who's listening to this is try and think beyond the box when you get out of Jindal, and when you are possibly in the position of having such collaborations. And the reason why I say this is that I feel like this project was an excellent example of academic rigor combined with journalistic vigor in some ways, where the foundation was laid by excellent work that Lubhyathi and her team did. And then reporters, sort of took over from there, and then they went to the ground and actually ground truth it, sort of saw what was happening on the ground, came back with very rich insights of what the data itself might not tell you. For instance, the data will not be able to tell you just how complicated things are on the ground, or what were the factors that motivated the imposing of sedition charges on certain individuals and not on others, for instance. So I feel like I don't want to sort of drag on for too long, but I feel like these collaborative efforts are what we need at this point. And if we can get more of these, then I think people on both sides, not just journalists, but even academics, would be delighted with the outcome.
Thanks, Kunal. The same question to you, Lubhyathi, very quickly. If you could just perhaps give us an example. You've lots of examples with me separately, but just for the sake of audience, about how data misses things and how ground level work and collaboration with field researchers and journalists in particular can enrich data work. Very quickly.
Yeah, very, very, very quickly. So in one case in Karnataka, and Mohit Rao, an excellent investigative journalist, reported for us from Karnataka. We gave him 6 bail orders, 6 different men, who all posted the identical clicked on the identical Facebook post, and they had sedition charges filed against them. Now, all 6 bail orders, incidentally, were identical in content. The cause title was different, but otherwise they were identical. And these are 6 different men. Just on a reading of bail orders as desk-based researchers, when we first sort of pulled them out, it's pretty obvious to assume that they were part of the same WhatsApp group. And, yes, it was a group message that was sent. They were all arrested together. They were probably together in one room somewhere because they're friends. And it's only when Mohit went to the ground, and again, he was able to track people based on that order, based on the cause title, the name of the district, the name of the court. And he is, of course, as an investigative journalist, was able to do that. And he found out that these are 6 different men in completely different districts. They had nothing to do with each other. They had never met each other. They had met in jail for the first time, and sort of then understood that they were arrested for the same Facebook post, which also tells us about Facebook's own algorithms, but that's a separate conversation. So this is just one example of what, as desk-based researchers, when you just read a bail order, the bail order does not tell you anything else, really. I mean, it gives you very limited information. And it's only when Mohit went to the field and tracked them down that he was able to find out everything about them, everything that we in fact earlier alluded to, that they're semi-literate, that they couldn't speak English, that they did not understand what was on the post, they did not know what they clicked. All of this came through speaking to them, and which again adds to the complexity of what our data finds. And another example, again, where we'd earlier spoken of these cases filed in the aftermath of victory processions, around elections. And Dhirendra Jha, who reported for us from UP, found out that in one case, BJP workers filed a sedition case against Samajwadi Party workers. And this is something we knew from an e-courts, the sort of document that we pulled out. But the document is, again, very bare. It does not give you any information. It only tells you that there's 124A imposed against, these 10 people with their names. And Dhirendra was able to go to the field and talk to them, and then found out that, Section 124A was actually added as an afterthought by the police. It was handwritten into the FIR. And it was done as a way to sort of allegedly prevent the Samajwadi Party workers from contesting elections, because they would have to be arrested and be in jail if there's sedition, since it's non-bailable. So this you cannot get from just a reading of, a court document. This kind of depth and complexity only comes out when you actually go there and you speak to the police station, you speak to the accused and the families. And so, I hope that's a short answer, but this is the kind of collaboration that, Kunal was talking about, and why it makes data work, especially in India, especially in the country we're in, where simply numbers also cannot give us the whole story, as we discovered from our work. Yeah,
I think I was just quickly going to add that I was about to say that, that's one part of it, but the other is, that data alone can't humanize these stories, because finally at the end of the day, these are stories of struggles of people, sometimes, the most marginalized, sometimes the most vulnerable in that part of society. And that suffering cannot be captured by data. So you need to humanize these stories. You need to bring them out to really reveal the full extent of what a vindictive state can actually do when it wants to. And that is the reason why such collaborations again are so critical in these times.
Absolutely, and add tremendous nuance to our findings. So, for instance, Lubhyathi's example of the printed FIR and a handwritten sedition on the FIR provisions just tells us, just by a bare reading of it, what exactly may have happened behind the iron curtain, so to say, right? And how do institutions actually behave, which is obviously a great learning for researchers. I just wanted to end here. Thank you so much, Lubhyathi. Thank you, Kunal. This was a wonderful conversation. And my gratitude also to all the audience members who joined us. I just wanted to end partly in responding to a question that an anonymous attendee raised, which is identifying the issue is great, but what's the way forward, especially where the state machinery is the offender? And that is a golden question. That's not something which obviously we addressed in our panel. Part of perhaps the answer would be that this issue is before the Supreme Court again. The Supreme Court is assessing the constitutionality, or hopefully will be assessing the constitutionality of the sedition provision. And one major way in which all of us can contribute is by reading and talking about it with as much clinical precision and social scientific rigor as possible. And that is why we ended with the methodological issue, because I think it has to become, fight against these kind of laws also has to become a democratic and inclusive process. And irrespective of what the Supreme Court does, I think there is great value in continuing to do research and continuing to critique socially. This is a constitutional value that we can't just give up on. But beyond that, I hope, anonymous attendee, you'll find your own ways of moving forward with this struggle. But thank you so much. Thank you, Kunal and Lubhyathi. Thank you to all the organizers, Bhavni, Suyash, Piyush, our IT colleagues at Jindal, and of course the audience members for finding time and talking to us and sharing your questions. Thank you, and please take care of yourself.
Thank you so much.
Thank you so much.
Bye.
Bye.